presenters today. We have Maureen Molesky and Laura Pike, both members of the Berks County Board of Assessment. Maureen earned her real estate license in 1971. She became an assessor for Berks County in 1979, where she held her position for 26 years before retiring. Maureen then became a member of the Board of Assessment, where she has held her position since 2008. Laura earned her real estate license in 1994. In 2004, she began her apprenticeship as a real estate appraiser, and in 2008 obtained her general appraiser license. She has held her position on the Board of Assessment since 2016. So welcome, Maureen and Laura. Thank you so much for being with us. And we're going to take the floor.
Thank you. Hi, everyone. Thank you for being here. It's nice that people want to educate themselves on what is going on with assessment appeals. There's a lot of people that don't really understand how this works. So if you have any questions during our presentation, please feel free to ask them. Okay, we're going to start with, up on the screen here, we have the Berks County assessment page. This is where you're going to get your appeal form from. You're going to click this right here. You're going to go on to the Berks County. Under the departments, you're going to go to assessment. You're going to go to forms and the appeal form. You click that and it pulls it up for you. Okay. August 15th is the deadline for filing an appeal. The county, the assessment office has to have the appeal in their hand by 5 p.m. August 15th. It starts on July 1st that you can file your appeal. So anytime from July 1st to August 15th by 5 p.m., the appeals can get filed. Any questions? Yes.
So new construction appeal period, can you talk about that at all?
Yes, we are definitely going to talk about that. We can talk about it now while you ask. Those appeals, once the assessor assesses it and the owner gets the notice in the mail, they have 40 days to file the appeal. So 40 days from the date it was sent, correct? They have to appeal it. That is not between July 1st and August 15th. That's within a 40-day time span. If they don't appeal in time, then they're going to have to wait for regulars. And regulars, we call regulars the ones between July 1st and August 15th.
And it's a forward tax when we have these regular hearings.
The appeal form that you will print out from the site, we can go over that quick with everybody to make sure that they know and understand everything that we have on it. There's a $25 fee for residential and farms and a $100 fee for all other classes. Make sure you include that fee with the application. Let your clients know they have to include that. And make sure they sign their application form, or else it can be null and void. Okay. And they have to fill it out completely, all of the lines they have to fill out. The people that can appeal is the owner, an equitable owner. So if you have a client that has an agreement of sale on a property, they may file an appeal within the time frame, within July 1st to August 15th. They may file as an equitable owner. Okay. If you are dealing with a client who has a trust, LLC, LP, corporation, any entity that is not a person's name, the owner's name, then they need an attorney. They need an attorney to file and to be present for the hearing. Any questions so far? Okay.
And the builder cannot act as
Yes.
the attorney.
Now, yes. Very important thing. You can help your clients, you can give them the comps they need, you can be with them when they call in for the hearing. This year, we're gonna have the call-in again because we weren't sure what was gonna happen with COVID. So we are not having people come into the office, it'll be via telephone again, and tell everybody be prompt with their phone calls to the county. But you can help them, you can be with them. They have to be present on the phone, and they should talk to us first. I mean, the realtor can say that they're there, they can say who it is, but we have to talk to the property owner. You cannot act as an attorney. An attorney can do all the talking and, speak for their client. Realtors cannot. You can talk, but we have to know that the owner is there.
In lieu of an attorney, can they have an appraisal
For which people?
for the LP or,
They still need an attorney.
they still need an attorney?
Yes.
Okay.
Yes, they still need an attorney. That's all.
In the equitable ownership situation, does the owner of it have to approve or allow the appeal?
No,
You're under contract.
you're under contract, you're an equitable owner, you can appeal. You can make sure that we've already gotten an appeal from the owner and an equitable owner, so have a conversation to make sure you don't both apply. But, yeah, no, they don't have to. As long as you're an equitable owner or the owner, you can apply. Okay. So, what you need to make sure your clients have for the hearing. We request comparable sales within 6 months. Now, sometimes that's difficult to come up with, as long as we get at least 3 in that tax year, So you're filing in 2022, so all the comps should be from 2022. We don't want to see ones from 20 or 21. We don't want to see that. If it's a difficult property to come up with comps for, suggest that they get an appraisal and make sure that's dated for the year that's being filed. Like this year would have to be dated sometime in 2022. Okay? Any questions? All right. You have to let them know they have to provide a picture of the subject property, a picture of their home. And when you give the MLS sheets, typically that has a picture of each comp. So we need a picture of the property that's being appealed and pictures of the comparables.
And also, we want all of this information prior to the day of the appeal, so it can be put in your folder. But we can go over all of this before the phone call comes in, and we know what we're looking at.
Yeah, it used to be that you could bring it in with you when you could come into the office, but with it being via telephone, you're better off if all the information is included with your appeal. If you don't have all the information at the time of the appeal, like we're having a discussion before class started, if you have a property listed but not under contract and the owner files an appeal and then it gets under contract before your hearing but after you filed, you can drop off the information or mail it to our office so that we have it before the hearing. They'll put it in the file then. Does that make sense? Okay.
We want to be friendly, taxpayer friendly.
Taxpayer friendly, yes. If it is an income-bearing property, you have to include the income and expense information because that matters. And if it's a big income-bearing property, an appraisal might be a good idea. But if not, at least include the P&L papers.
If it's not an income-bearing property now, but potentially someone, then what?
It's as of the date of the
Okay.
hearing, so
Okay.
if it's not at that moment an income property, then it's not necessary because anything that you give is an estimate, it's a guess.
Right.
Any other questions? Okay. Right.
Yeah.
You have to fill out on the form the basis for the, oh, sorry, go ahead.
Details of all the things that you need right on the appeal.
Yes, yes, the appeal form has all of this information that we're going over. A lot of people don't take the time to read it, so we wanted to go over it just to make sure that everybody knows what's on the form. We tried to make sure the form gives all the information that people need.
I only asked so that I would
Write
everything.
everything. Right, right. Okay. When you give your reason, your basis for the assessment appeal, saying that it's a financial hardship is not a reason we can lower anything. It just has to be proven that it's incorrect. We can't lower it because you're nice and you can't afford it. We can only lower it if the comps show that it's too high. If it's assessed too high, then you apply the mills and the taxes are high, but if we can reduce it because it is too high, then we can help out with that. If your client does not call, say they're scheduled for 10 o'clock on August 15th, and they don't call in, they lost their shot. Now, if there is an extraordinary circumstance, we had a gentleman, when people were coming in, we had a gentleman who got in a car accident. He was at the hospital. He left the hospital against medical advice to come to the hearing. We were like, no, this is an extraordinary situation. So you can call and explain what's going on, and we can try and accommodate something like that. But it can't be, oh, I forgot. That's not going to cut it, because if you're appealing it, it's important to you, so you should remember when the hearing is.
Possible to reschedule if it's an inappropriate day or something.
Yes.
Don't you pull me away from the settlement table out of their property.
Well, it's on the form, if you're on
Yeah.
vacations, you should put that on the
Oh, good.
form,
Yeah, the
when you
form.
are not
The form says dates unavailable.
available, so fill that out.
Yeah,
But we work around them, the schedulers
Feels
work around
appreciated.
that.
yeah, we try and be taxpayer friendly.
But if it only be user-friendly to so many people at once.
Right,
don't
right,
know.
that's one of the things, we can't have everybody call in
Right.
after they're all scheduled and say, oh, we can't do it then, because then we're gonna have a lot of problems, because we have a time frame we have to hear all of them by. So,
What is that response time?
By the end of October, we have to, I think it's the 20s, in the 20s, because the pro rata sheets have to go out to the municipalities so
Oh,
they
right.
can work with their budgets for the following. So they want to know what we did as far as lowering,
Sure,
so we are on a time frame.
sure.
right, make sure that you or your clients, we blew this up.
See it.
Make sure everybody fills out all of the information here, the property ID number, the owner of record, the appellant, mailing address, all of it. Just make sure everybody fills the entire thing out and signs the bottom. Okay,
If they have any questions, they can ask the office.
yes. Now, the common level ratio for 2023 is 45. So it's 45%. Everybody has one of these sheets at their plate. Try to make it simple, easy. You take the property value times 0.45, and that gives you an accurate assessment. So if you have a property listed for $575,000, an accurate assessment would be $258,750. If it's higher than that, then you know they might want to appeal. If it's lower than that, I wouldn't suggest appealing.
No way.
So, does anybody have any questions on this? I know some people get the common level ratio confused with the common level ratio factor. The factor is what the recorder of deeds uses. Attorneys will use that. That is not what the assessment office uses. The assessment office uses the common level ratio, which is 45% this year. Last year, it was 52%. 21, it was 56.3. Now trend of going down right now. But we do not use the common level ratio factor. It's not a huge difference when the property values are lower, but once you get in higher value properties, then it does impact it.
Give you those two numbers again.
Which numbers?
The years, the previous years.
Oh, yes. 2022 was 52%. 21 was 56.3. And in our office, we have it all the way back to 2004 for our records. We keep
Is that online?
This is not, if it's important to everybody to have a copy of this, I can see if the board would be able to. Right, yeah. So
That's why I got it, but it's telephone.
yes,
How would you judge?
right,
How would you judge
yes.
every year what
Now, to determine the taxes for your clients, we do not deal with taxes. We deal with assessment. Tax claim deals with taxes. Different departments within the county. We were having a discussion. Miriam had the millage paper with her. I did explain to her, these mills do not include the county mills. This is just district and school. We did just have a conversation with the woman who makes these sheets. We had the conversation on Monday. So we're gonna see if she can add the county into this, so it's accurate information for all of us. But you may wanna write down the county mills, so you have it, you can add it. It's 0076570. So it's 0.0076570. So you would add that to the total here to be able to get the correct taxes for your clients. What is the county? It is 0.0076570.
And that's the county tax.
Yes. Now we want to open the floor to questions because typically there are people that have specific questions which can be helpful to other people. So are there any questions that anybody has?
I have a question on the whole process. Years ago, we as realtors or negotiators could go with our client with the paperwork, you know, when it was their appointment. And my understanding is that's changed or not?
Because everything's via phone call right now,
Oh, it's still going on?
yes, yeah, hopefully next year's appeals will be different. But when we had to decide that, there was the talk of another strain of COVID coming, so we didn't know if it was going to be closed. And it's easier to plan for it now than change it once it's already scheduled. But you can be on your phone or calling into the office with your clients with you. That's fine, you can help out that way, but we have to know the clients are there because otherwise you're acting as an attorney, which is not. But yes, you are allowed to help them. And a lot of clients don't really know what they're talking about, so as long as they introduce themselves and say you're there to help, then you can explain what your comps are and the reasoning for it. And give good comps. We've seen some, you know, you have a 2,600 square foot home and comps are like 1,200 square feet, 2-bedroom ones. And I'm like, that's not really comparable. So, right now we're not really dealing with bank sales, but we've seen that bank sales as comps for a nice property, which is actually listed way above what they're trying to say it's worth. So just give good comps so we can help them. Any other questions?
For a POA,
You have to give your paperwork.
yeah, give a power of attorney, you need a copy of power.
Yes,
Yeah.
yes, you have to provide the power of attorney paperwork.
Yes.
Does it have to be an appraisal or can it be a CMA or cost?
You can do a CMA. You can do a CMA with this. You do not need an appraisal. You need at least 3 good comparable sales within the year that you're filing, not within a year, but sold in the year that you're filing. We like to see within 6 months, but you know, sometimes that's not possible.
The common level ratio going down is pretty much balanced by the prices, market prices going up.
Yes, that's
So
the
that-
point of it.
right.
We get the common level ratio from the state. They try and equalize from the last time our countywide reassessment was. So right now,
Right now.
45%, yes. So the market changes, then, you know, we'll see what happens there.
Do you have plans for a countywide reassessment?
At this time, no. Our assessment office did just get a new computer system. So, we're, you know, new computer systems, you have to work the bugs out. So we'll see.
Take years to do it.
Yeah, we'll see how long that takes, and then we'll take it from there. Any other questions? Please feel free to ask. Now's your chance.
So the basis of the common level ratio, is that based on 2021 sales numbers or closed sales? How is that, you know how that is?
Yeah, the state is actually like 2 years behind.
So it's 2021.
Right.
Okay, so the dates that I'm seeing on here about the 2021, that would be accurate, but not just types? Or, because it was mentioning about 2021 on here, and I was like, is that from the calendar year 2021?
Right.
Is it 2020?
Yeah. So that's accurate.
Okay.
That is accurate. This is actually, the paper from the state.
Very good.
Okay. Any other questions? Yeah.
When will a countywide reassessment look like? When will we do that?
No. Typically, they say,
It's third. Remains the same.
did everybody hear that in the back? They say typically a third will go down, a third will remain the same, and a third will raise. That's what they say.
If I have to mail, like, a food that I get some contract prior to our meeting, when I make it to someone's attention, or are you going to be handled
Here, right here.
So I'm just sending it
It's, yeah, on the top left corner of the appeal form is the address, that's who you will send it to. And when our office gets the appeal forms, we timestamp everything. This way, nobody can come back and say, oh, wait a minute, you know, we did this then. No, we have it this date.
Okay.
So everything gets timestamped.
And then you're notified as far as the time and date of your hearing.
Yes, yeah, you'll get a notice in the mail.
But I'm saying that after, if I send this yesterday,
Okay.
and it goes on the contract after.
When you can either mail your contract information or drop it off at the courthouse. And when you do so, you will let them know what property address it is for. If you already got your notice for your appeal, that you know what day and time it is, make note of that and with your information so they can easily find the file.
I'm curious, where it says state reasons for filing the appeal, say I
Some people do that, and some people will just put assessment too high.
Values.
Because
some people's assessments are too high, especially new construction. We were talking about the new construction earlier. And if you're working with someone and they are buying new construction, if their assessment is pretty much based on their sale price, you'd be a great realtor to tell them appeal. And do it within 40 days. As soon as they get the notice, tell them do it right away. Because the assessors cannot apply the common level ratio, only the board can. Okay? Yeah, they cannot. I can't.
Two questions. One, how much, like you said, end of October is when the decision will be made. For new construction though, it's submitted, say, January. What is the time frame for you to get back to them when it's out of that cycle?
Usually then it changes now. So
Right,
they're monthly.
monthly. We
Monthly.
have hearings
Okay.
every month for
Every month.
changes.
And the second thing I was wondering if you could speak regarding is, some of the school districts now are changing ordinances and some of the rules and regulations on how the school districts themselves appeal. But Governor Mifflin specifically, I know, has made some major changes in my mind with what they're doing. Can you speak regarding that or explain any of that to us? Or,
There is precedence law set by a court case in Allegheny, okay, which the judge decided that the school district is allowed to file an appeal for a property that was recently purchased and the assessed value is low. But there are a bunch of school districts in the county, including Mifflin, that will file. They all have different criteria. If some of them are, if there's more than $100,000 difference of assessed value, some of them are 150. There's one of them that's actually 500. So it's not a uniform set of numbers for all the school districts, and some school districts.
is that problematic
Or not.
for you guys? No, versus, or you, when you get an
We
appeal,
have-
you get an appeal?
When we get an appeal, we have to hear it, and we have to follow the law.
So you have to know, have to be knowledgeable of all these changes that they're making, all these. rules.
Yeah.
Yes.
Yeah, yeah, so we do have a solicitor that we refer to when the school district started filing. We got a bunch of information regarding the court case in Allegheny and spoke with our solicitor to see what we were supposed to legally do.
So from our standpoint, I don't know what help the appeal board can give one way or the other, but it's very confusing when a buyer is buying in Governor Mifflin versus Kutztown School District or somewhere else, to advise them, like, this may be a concern, if you pay X amount of dollars above, the assessed value, how will we as realtors be educated and notified and all, you know what I'm saying? Like,
Right. We don't
is there
know
any
that.
place that we can find that information now?
We don't know. We don't,
That's-
right? Until
So,
the appeals come
that's
in.
why I was asking if you guys, it was confusing for you as well.
We know it's a school appeal,
Yeah.
but we don't get any information of what the property is. And what is funny, years ago, when I worked for the county, we were taken to court because every time a house was sold, we would raise it. Well, we were taken to court because it was considered spot reassessing.
Right.
Now, the schools, they're not under that rule. They can do what they're doing.
Yeah, and they don't consider it spot reassessing for the
No.
school districts because they have a set of criteria that they have to meet. If something falls within that criteria, then it's not considered spot.
What school district is it that looks at it at $500?
Oh, 500,000.
Oh, I see. what
Right, sorry. It was
you're saying. Okay,
500,000.
that's pretty petty.
Right, no,
Yeah,
no,
no,
not
no.
500, but 500,000.
Why Mifflin?
Why does new construction get killed so much? I mean, not every house is $1.5 million being built, but the taxes are incredible. And I guess second to that, I assume whenever we do a reassessment, those guys are going to be in the top third and just get pushed even higher.
One of the issues with new construction is the assessors are not allowed to use the common level ratio. So when they place the initial assessment on, sometimes it's based on cost. They have to put all the information into the computer, and the computer will help them generate the cost. And typically it's a sold property, so they know what the sale price is too, but again, they're not allowed to tell the common ratio.
So almost basically every new construction should appeal that at that point, because the Commonwealth ratio is not being incorporated into the.
Well,
Is that what I'm hearing?
Yeah, this sheet that you have
Yeah.
is the perfect way to figure it out. You put in the sale price times the common level ratio for that year, and if it's higher than what it should be, absolutely.
You say 2022 was 50.5 months?
52.
52 even.
Yes.
In that hypothetical countywide reassessment, and the third will hypothetically go up, isn't there a limit on how much they can go up because the millage would then have to be down?
That's,
I can't answer that.
the company will do that. We had before Collier Trumbull did the master assessment before.
Well, that's the assessment,
Yeah.
but then the millage,
That's the school.
Yeah, the mills, for the
Yeah.
school
so there is
district.
no limitation on how much.
I'm not aware of the correct answer for that. That's a really good question though.
They're not looking at a countywide reassessment. It's very, very costly. Very costly.
I don't think there's ever been a county commissioner to be elected yet.
You're right. When you're all ready to retire, when you're the last one, then look out.
No, they never would do that before, but we were forced, so we had no choice.
Yeah, the county was
There
taking
was
it
one
for
or Delaware County members were on it.
Yeah. There are some counties that will do it yearly. Their computer system will just generate it, and they will do it yearly, or every 2 years, or
Which we should, the right
3, 4, or 5. Yeah.
I had a listing at one point. The house was built
Okay.
in, I think it was either 2003 or 2004. And the taxes were extremely high. So I compared it to the same type of house, everything else, in another development that was built a year after. And it was unbelievable. It went from $8,000 in the other development to $12,000 in the year that they built. I think it was 3 or 4. So I called the assessment office and I said, hey, what's going on here? You know, it's the same kind of house. And they said at that time, that 1 year, the assessment for new construction was 100%.
Yes.
Wow.
And I said to them, why haven't you notified these people? And they said, that's not our problem.
Well, in 2004, okay, in 2004, the common level ratio was 90.4. The point of the common level ratio is to equalize everything with the 1994 reassessment. Okay?
Going back to that.
Yes, to keep everybody uniform. But yes, there were years the market was equal to
Yeah.
94, so that's when it was 100%. And some people were confused and saying, this is wrong, but we get these numbers from the state. We have to use these numbers.
So I think the average realtor should kind of watch that.
Yeah.
If you have one that was built in that year,
Yeah.
look at it, because the owners won't.
Which one?
Yeah.
In 2004, it was 90.
I owned the property that split the land off in 2003, so I think it was 2004.
Yeah. 2004 was 90.4.
Yeah.
And I'm sure 2003.
And then they said the
was
next year,
higher.
it wasn't.
Right, no, in 2005, it was 86.3, and it's
Going down.
going down.
Yeah.
Right.
It's something you should watch for when you're listing a property, because no one wants to buy a property that's way over the tax,
Right.
and the
But you
owners just
can
don't
let-
understand.
You can also let your clients know, and a good way to keep them, your clients, for future, is kind of keep track for them. So 3 years later, if they bought it and it was 100%, 3 years later, it went down to 80% or 75%, tell them, hey, you guys should appeal now. And then they'll call you when they want to sell and buy again. Yes. Yes.
Clarity. The 2023 45%. If I'm under contract with somebody and am I using this 45%, am I using the 2022 number?
You're using the 45%. Because the 2023 are hearings that are heard in 2022.
Yes.
Because it's a forward assessment value, so it will apply for January 1st for county and township, and then July 1st for school. So it's a forward tax. Okay, that's okay. Any other questions? Nobody?
Do you have a list of the school districts that are appealing at this point? Is there certain school districts that you've seen coming in?
We typically find out at the time of the hearings. We do know of some of them that do.
Is that public information or something you can share with us? So we know? I don't see why you wouldn't be able to, but just if we get the list as a realtors association, so that when we're working or selling something in those school districts, we know to keep an eye on the report.
We don't know.
Right.
I don't want people to give me information.
Yeah, we're not aware of all of their criteria, but we know solicitors for Reading, Wilson, Mifflin, Town.
Those are the four that I'm aware of, that's why I'm asking.
Yeah. Yes.
That's why I'm asking, what, if there are others that are out there.
But we don't know until the day of the hearing that it's a
Right.
school.
But those are the four that you've seen.
Yes,
Yeah.
yes.
It also highlights the importance of participating in municipal elections.
Yes.
Talk to the school board candidates.
Yeah.
And they're-
And part of their purpose of appealing is they could see a property that's sold for $1 million and it's assessed at $150,000, and their take on it is that's great for that buyer, but it's not fair to everybody else. So they're looking at everybody paying their fair share. So not to say anything one way or the other, just being devil's advocate here on giving their reasoning.
Do you think it has something to do with them tearing down Fairgrounds Mall because of the assessment?
No, we don't.
Oh, we did hear that they wanted it lowered, so they did that, but that was hearsay through,
Yeah.
poor people, so.
The reason that they tore that down was not in their assessment. After it was torn down, then they argued that now the buildings aren't here, so our assessment should be lowered.
They're from out of the area. Any other questions?
So what are the four school districts that we should keep an eye on?
We don't know the criteria.
Right.
We don't know that.
We know,
Well, just in the past, who are the ones that you've heard to keep an eye on?
we know Wilson, Mifflin, Reading, and Kutztown. Kutztown, last we heard, has the higher, the 500,000 criteria.
I thought it was 750, but it
It
was
could have changed. Last I heard, it was 500,000, but
I think Mifflin was the least, which was around 100,000.
yeah. And Mifflin's recently changed. There was a whole hubbub about that. Yes.
And what was the rate for the 2003?
Yes. In 2000, oh, no, I don't have that one. Ours is 2004.
Well, I can tell you what it was 100%, because every time the house sold, we raised it on that sale price.
Wow.
That's how we got into court, because some people really complained about it. Because it wasn't fair, because people had lived in their homes for all these years, and their assessments never went up unless they did something to the property, pool, addition, garage. So that's how we got it. Yeah, everyone that sold, we put it on the sale price.
And this doesn't have to do with filing an appeal, but this is just information for you to give to your clients if they're ever in a situation. If you have a client who's buying a property with a couple acres and it has a building that's gonna fall down, so they say, we're gonna tear that down. Tell them to contact the assessment office when they do remove it, when they raise the building, because the assessment office will send out the assessor for that area, and they will remove that from the assessment. Okay, so that's just knowledge for you to, yeah.
Question about home improvements. Somebody adds a porch and deck and things, and they get reassessed because they had done that. Are they going to reassess the entire property or just the improvement?
No, they can only make changes to what was changed on the property.
The improvement.
So that can open.
And if it's a replacement, I think it's a little different too. I mean, how we, reassess it, just the deck.
So if they add a porch and a deck and an in-ground pool, okay, they're making changes to the pool, the deck, and the porch. When they appeal it, if they don't like the numbers and they appeal it, because they do have the opportunity to appeal that, that's a 40-day time frame too that they have to appeal it. We can't take a full appraisal from them and change the entire assessment at that time during a change. We can only do that during the regulars. We can only look at what was changed. So if you have a client who is adding a porch and they paid $8,000 and they get a notice saying it went up $15,000 and they want to appeal that, they can definitely do that. But let them know we can only look at what was changed.
Will they look at the full cost of the improvement or on the common level?
We look at the cost and we can apply the common level ratio,
Like
but
if they
again,
spend
the
$50,000
assessor.
in a bedroom on or something like that, would it be the 45% or would it be the full 50?
We
Trying to cost it out per square foot a lot of times.
Yeah,
Trying to
and,
cost it.
but we definitely we can apply the common level ratio, and we definitely try to be taxpayer friendly because we pay taxes too. We get it.
Yes.
So why do you apply the cost of a pool when an appraiser won't give you the cost of their pool?
The assessor will apply the cost of the pool.
No, like if I put in a pool and it cost me $50,000, and then I sell my home, an appraiser's not gonna give me $50,000 for my pool.
No, they won't.
So why do you tax me on $50,000?
If it comes in front, if it comes to the board, we don't do the
Okay.
50. Both were realtors. I still am. You know, in our careers, Maureen was an assessor for 26 years, so she gets both sides of that, and we pay taxes too. So we do try to be taxpayer friendly, and we try to be as fair as we possibly can. There's nothing frustrates us more than when we get an application in and there's no information included. And we have to say, no, and we see the property, we know what it is, and we know it's overassessed, but without proof, we can't do anything. So, help us help your clients.
Does anyone in here deal with mobile homes at all? Because we tell them to come in at least every 3 years, and we kind of.
I tell them.
Okay.
Yeah, if you have a trailer, we have a chart from the state that we use. You don't need comparable sales for trailers. We,
No.
right, right. We have a chart that's provided from the state that we have to apply to depreciate it every 3 years.
So actually, for a trailer, you don't have, you just have to file this form, and the owner will be on the phone call with you. You as the realtor have
Nothing to do,
because you don't
right,
do comps.
right. Unless it's a trailer that's pretty much dilapidated and you have good comps to
Right.
show and send a bunch of pictures in. Now, if they're gonna fix it up and live in it, don't try and play games because the assessors will see that and then it'll go back up. So, yes.
So now, if you have a really old home, 1849, and there's really not a lot of comps, and you use like that area as, I mean, not every 6 months, you have to do that.
Like when you have a unique property, I know it costs money, but sometimes the best bet is to get an appraisal. Because if you're gonna give comps and they're gonna be 2 years out, we can't use them. But if the appraisal is dated 2022, or whatever year you're filing, right, we use the appraisal. So if you can find comps within the time frame. But yeah, we've had situations like that, you know, it is an old home and they're giving like comps that just are nothing like it, and without good information, we can't help them.
For the trailer, I've only sold one trailer since 1971, I started saying.
Oh.
Want to compare like numbers? But when, in what circumstances, I know for sure, and in general, I pretty much think that trailers are always on rented property. So how do they then get assessed? Is it just like assessing an automobile for a trade-in?
Or are you talking about a trailer that's on lease? The owner of the ground, he gets a tax bill, but the owner of the mobile home also gets that tax bill in their name. The land is in the owner's name.
Okay. Okay, now taking that one step further into the realm that I'm more familiar with. When a builder starts out a subdivision, the lots, individual lots are assessed based on the individual lot.
Correct.
And then they are reassessed at settlement.
And
How does, where is it,
All
or
right,
a
if
gap
there's
period
a-
there?
There's a subdivision, and it's still farmland, and the builder bought it. We have a lot number, so we will put a low value on that because it's still farmland. Once they cut the road in and the utilities, then it becomes an undeveloped lot.
Right?
And then once the house goes on it, then it becomes a developed lot, which the price will go up, and then we add the house onto that.
Sure. But there used to be a gap between the settlement and the taxing time. There used to be a gap in there, and then the buyer of the new construction home had to pay that gap.
Yeah.
Right. Exactly.
He's paying on the
But
land,
he's still paying on the land until it becomes occupied.
Correct.
Is that correct?
Correct. so it's
That
deeded
is-
from him to the new owner.
Correct. So it's deeded.
So, well, they're probably getting they're having a settlement.
Yeah,
and
yeah,
a
yeah,
deed
yeah,
comes in.
yeah, that's right.
Then it goes
Yeah.
from the builder to the new owner.
Correct, okay.
And all the taxes are
Okay,
done at
so
settlement.
the taxes at that point are the lot taxes are to the builder. And he only, but now they filled that gap tax.
Exactly,
Yeah.
unless that builder sold the lot to the owner of the house that's being built, then he would get a tax bill just on the land. And then when the house goes on, then we pick up the house and put that on.
Right.
Yeah.
This is why we keep her.
So to be
All the
clear,
marinas for years.
so there's three assessments on the subdivision.
Pardon me?
So there's basically three assessments.
There can be,
So when it's first recorded the plan, there's an assessment. When they improve it with roads and infrastructure, there's an assessment. And then when it's built on with the actual home, there's assessment.
correct,
Okay.
correct.
Quick question back to the trailer thing. I ran through something a couple of times. One, if there's a metal plate on that trailer, it's not considered real estate, it's considered a motor vehicle. The other thing is, so that's a problem we ran into. Unless you get a retired title out of Harrisburg, and we don't care how many years ago, it was, it could be 40, 50 years ago, that's considered a vehicle.
No matter what we think, we have to follow the law, and they're taxed.
As real estate or as a vehicle?
As real estate,
Even though it's not-
because they live in it. No matter what our personal thoughts are on it, no matter if we agree with what you said or not,
Yeah,
we have to,
yeah, because when the
But-
plate comes off
but
and then
you
you get the
can-
paper from Harrisburg, then it becomes real estate.
yeah, but they can, as they get older, they depreciate.
But of course, in 1972, they were zero at that point.
It can't be zero if somebody's living in it. It can be zero if it's burned and nobody can live in it, but it can't be zero.
Because they had those strange, those dates, that if it's before that date, it has no value. Because something was like the trailer.
I didn't hear the entire.
Something about HUD had the thing certified at beyond 1972, it had to be built a certain way, so prior to that, there was no value.
We will ask for a solicitor about that. I don't know how many we've had in the county that are older than that, but we will definitely ask
So
for a
you get a
solicitor.
couple of them up in 78. Okay.
Thank you.